You may be seated. Let the record reflect that the court is back in session, cause number 332118, case of the state of Texas versus the nation. Danae Matoir, Ms. Matoir is present in court with her attorney Wright Kimler. Today is present, Assistant District Attorneys, Attorney Andrew Hubel and Attorney Haley Simmons. Let the record reflect that your jury is now present and seated in the courtroom. And the state has rested. Mr. Kimler, would you like to proceed?
The state's rested on the record, you know?
Yes, they rested before we went into break.
Your Honor, may I approve?
Yeah.
I've marked this item that Detective Boudreaux drafted as defense exhibit 3, and I believe it's time to enter that down.
State?
No objections, Your Honor.
Okay, no objections.
Your Honor, recall-
Defense exhibit number 3 is admitted. Mr. Kimler?
Your Honor, recall the issue.
Ms. Matoir, would you please come forward? Ms. Matoir, would you please raise your right hand? Ms. Matoir, do you swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Matoir, you may put your hand down and take a seat on the witness stand. Mr. Kimler, you may proceed.
Would you identify yourself by stating your full name and spelling your last name?
Initial name was Wire, last name was Wire, Metoyer.
Can you pull that microphone a little bit closer to you?
Oh, it's not.
It's not.
She has to reconnect it.
Ms. McQuire, how old are you?
36,
And where do you live or reside?
right now I live with 39th Street, in Fort Worth, Texas,
And how long have you been a resident of Jefferson County?
all my life, 36 years,
And how long have you been a resident of Fort Lauderdale?
36 years.
What's your educational background? How far did you go to school?
Graduated high school, went to college,
Where did you graduate from high school?
Richard Hill Burn Academy.
And where did you go? You said you had some college.
Yes, sir.
Where did you go to college?
No more forever.
And how much college do you have?
About a year and a half, process technology.
I'm sorry.
A year and a half, process technology.
And how are you presently employed?
I work at Fast Lane Shell Station
Where at?
here in Fort Worth, or in Fort Worth.
In Fort Lauderdale.
Yes, sir.
Which one do you work at?
Off of 9th Avenue, by the library.
And what's your job duties there? What do you do?
I'm a cashier.
What do you do as far as a cashier? What's a normal day for you as a cashier?
And, bring up everyone that comes in, process or they need gas, or bring up their gas, take the money, stock, take other gas orders, sign for a shell so that they could load gas into the ground.
Different things? all
Yes,
that?
sir.
Okay, how long have you worked there?
About 5 months.
And where did you work before that?
PAISD,
What did you do there?
I was a bus.
Well, let's back up. Fort Arthur Independent School District?
Yes, sir.
What did you do with Fort Arthur?
I
Independent
was a
School?
bus aide.
I'm sorry?
A bus aide was special ed.
What did you do there?
Help the kids get on and off the bus and strap them down so that we can get hurt while we were driving.
That's the special needs children?
Yes, sir.
What age groups?
From, first grade up until 12th grade.
And how long did you have that job?
About a year and a half is what.
And what did you do? What did you do before that?
I was in the refinery.
Okay, what did you do out, which refinery?
So, BSM Hotel,
What did you do out there?
I was labor.
And what would a normal day out there be for you?
Power host standing there watching, making sure everything is safe and correct, everybody is safe, the gears on, no one is doing anything, they don't have anything to do it.
And how long were you out at BSF Hotel?
2 years,
What did you do before that?
okay. I was, a nurse aide at senior rehab rehabilitation, yes.
What year was that, before or after the, hotel?
That was before Total.
And how long were you there?
Mm, 2 years as well.
What did you do? What were your job duties there?
I was a certified nurse aide and
CNA? Or-
yes, sir.
Do you have that certification still or not?
No, sir.
So you were CNA, and what did you do in that capacity?
Help the elderly get to and from bed, change them, clean them up, feed them. Just a day, regular day activities for the elderly.
And going back a little ways now too, what did you do, if you remember, before you were the CNA, what did you do before that?
I was at Barn V. I was in the kitchen at Barn V.
What did you do in the kitchen? Cook?
I did desserts. I did desserts and other train on his work.
This the first time you've ever testified in court?
Yes, sir.
You a little nervous?
No.
No, okay. You understand you have to tell the truth, right? And if you don't tell the truth, that's a third degree felony. You're 10 years in prison for aggravated perjury. You understand that?
Yes, sir, I do.
Very important. Okay.
Yes, sir.
Did you at ever time own a Tahoe, Chevrolet Tahoe SUV vehicle?
Yes, sir.
And when did you own that vehicle? When did you get it?
2019 and 2021.
Where did you acquire that? Where did you buy that vehicle? Who did you buy it from?
That's by Motors in Port Arthur, Texas, on Thomas Boulevard in Woodward.
Thomas and Woodward,
Yes, sir.
and that was a used car dealership.
Yes, sir.
And do you remember the man's name that you bought it from?
No, sir, no.
How long did you have that vehicle?
From the beginning, February 2019 up until November 2021.
And were you making monthly notes on it or payments?
Yes, sir, it was.
And what happened with that vehicle?
So the man, he passed away and I made my last payment. I didn't know where else to send it to. I found out he passed away. I still had the vehicle all that time. And, the vehicle broke down when driving,
What would it do?
when you drive it, I don't know, it's,
It would shake and
shake
pull.
horribly, pull to the level, of course, and, I didn't have funds to get it fixed, and it was multiple things wrong with that vehicle.
What other things besides the front end being out?
The shocks were very bad. The shocks were bad, and, yeah,
Was the engine still running in it or not?
it was running, but barely. One day it just stopped running. It's like, couldn't find a solution to it.
Where were you living when that?
So I put on the townhouse,
And what was your apartment number there?
1108.
So you had this Tahoe, Chevrolet Tahoe SUV. What color was it? And you say that this wasn't drivable, wasn't running, wasn't drivable. Is that right?
Correct.
What did you decide to do with the vehicle?
Well, I decided at the time, so when I seen to sell it, I decided to sell it.
What, could you drive it somewhere to put a for sale sign on it, or try to move it to put a for sale sign on it anywhere?
No, sir.
What, did sometime, the first one,
Yes, sir, ma'am.
did somebody give you one of these business cards? And reflect for the record, the manner in which we marked defendant's exhibit 1.
Yes, sir.
Well, they take a look at it to make sure. Does that look like a card somebody gave you?
Yes, sir, it is.
Who gave you that card? Do you remember?
No, sir.
Yep,
Yes, sir.
the person identified as Nelson.
Yes, sir.
And where did he give you that? Where were you when he gave you that?
My apartment, in Illinois.
Did he knock on the door and give it to you, or were you just walking into your apartment or back and forth, or where were you when he gave you that?
Actually, I was sitting in front of my apartment with my kids. He was putting these on everyone's car, but instead of putting on mine, he walked up ahead of time.
Okay, but you were in front of your apartment when he did that?
Yes, sir.
And you said you had your kids with you?
We were outside,
How many children do you have?
3,
What are their ages?
15, 14, and 9.
And what, do they live with you or do they
Yes,
live?
sir.
Now, they still live with you now, right?
Yes, sir.
They're living with you then at the time?
Yes, sir.
So would you agree with me that when Nelson, or the person who states his name is Nelson, handed you the card that's marked as Defendant's Exhibit 1, he could see where you lived, your apartment, is that right?
Yes, sir.
And knew that that was your apartment?
Yes, sir.
And when you looked at the card, did you think, oh, well, I have a Tahoe that I might be able to sell?
That was exactly what I thought.
Okay. Okay, so you could sell the car Tahoe that doesn't run or move and running or not, right? It says that on there. Okay. So what did you tell Nelson that at the time, or did you wait to call, or what did you do?
Everything happened right then and there. He handed me the card, I looked at it, I'm like, I have my timer right here, it doesn't run. I'm not getting it fixed, I can't afford to get it fixed. He was like, you have the keys, do you wanna sell it? I said, yes, sir, I do, but, how much will I be able to get for the car? He told me 300, and he wanted to see, needed keys and something to see that it was, I had made a purchase of the vehicle.
Did you have the keys to it?
Yes, sir.
And what did you have showing that you had purchased the vehicle? What documentation did you have?
It was a pink slip that, when you buy a car from a dealership,
Right.
they, your name and you know, how much it is and what it was, what the name, what the car is, and, you know, the year.
And you had that, right?
Yes, sir.
And did you give that to Nelson?
I had to show it to him, and cause I had the keys and he needed to know that was my vehicle.
Okay.
Yes,
And so did he give you $300
sir,
in cash or what?
in cash.
Remember the denominations? Was it 300s or 15 20s or what was
It was $300, $300.
it? $300 bill.
Yes, sir.
And did he ask you to write him a receipt or a bill of sale or anything?
No, sir.
He just wanted the keys and see the pink slip and that was all he needed, right?
Yes, sir.
And did he tow it off or drive it off or what did he do with it?
Well, at that moment, he was putting cars on people's car,
Mhm.
and he had to come back to get the vehicle.
When did he come back? How long did it take him to come back?
It took him, I say no more than 30, no less than 30 minutes.
Okay, so pretty that same day then, right?
Yes, sir.
Did he have anyone with him when he came back
No, sir. He was by himself.
by himself? And did he hook the Tahoe up and drive it off or what did he do?
He was the time home and drove it off.
Now, that's the last you heard about the Tahoe, last you dealt with Nelson or anybody, right?
Yes, sir.
Did, do you know Mr. Carter that lives out at the complex?
No, sir.
Are you familiar with this 97 Buick LeSabre that the subject of this case?
No, sir.
Have you ever seen that car out there?
No, sir.
After the individual towed your Tahoe away, were you contacted by the individual that you seen here in court named Detective Boudreaux?
Yes, sir.
When did he contact you?
I don't know the specific date, but he came to my house early one morning. And, he was my name really was for, I said, yes, sir, looking confused. He asked me if I owned,
Well, let me ask you this, was he dressed as a police officer
he was dressed casually, but his bag was shown.
like he was when he testified here like that, or was it,
More so a collar shirt, khaki pants, or cargos,
okay,
just casual.
had a pistol on,
I don't remember that part.
had a badge?
He did have his bag.
Okay. And so what did he ask you? What questions did he ask?
He asked me, am I Lanisha Couture? Yes, sir, I am. And, I asked what's going on. He asked me that I own and or have, 2004 Chevy Tahoe. I said, yes, sir, I did. Asked me that I sell it. I was like, My truck, yes, and that was it.
Did he ask you about a Buick LeSabre or anything in your recollection?
No, sir. I was asking about a dog.
And so to your recollection, you were never asked about the Buick LeSabre.
No, sir.
Did you sell a Buick LeSabre to Nelson or these guys, Nelson or Kevin?
No, sir.
Do you know what they're talking about?
No, sir, no.
When you found out you had a warrant for theft, what did you think?
I thought that I was going to jail. Because I was out.
You thought it related to the Tahoe.
Yes, sir.
You were arrested, right?
Yes, sir.
You were taken to jail, right?
Yes, sir.
Handcuffed.
Yes, sir.
You sat there and bookend, probably handcuffed to that metal bench for a while.
Yes, sir.
They put you up on the counter, with your hands on the counter, right?
Yes, sir.
Ran their hands over you, right?
Yes, sir.
Then they probably handcuffed you back on the bench, right?
Yes, sir.
Waited a while, then you were fingerprinted and photographed, right?
Yes, sir.
And then were you taken into the room and stripped down?
Yes, sir.
And I'm not gonna ask you, if you had a squat and cough, but they put you in a orange jumpsuit, right?
Yes, sir.
And then how long did you stay in jail before you were arraigned and made bond?
I don't remember how long. He was, I don't remember.
You don't want to remember, do you?
No, I don't.
When I told you it was theft, what did you think? What you thought it was theft of the dog?
My dog.
Why did you think that?
That's what I saw. My dog. It was broke down. The man was dead. It was mine. My dog. I was
Okay.
guilty.
We understand you're not charged with selling a Tahoe.
Right.
You're charged with supposedly selling a Buick LeSabre to them. Just to be clear for this jury, did you do that or not?
No, sir, I didn't.
I pass away.
Mr. Hubel?
Good afternoon, Mr. Sawyer.
Hi.
Have you ever, gone by the name Genesis?
No, sir.
No.
No, sir.
That's not in, also known as the vehicle.
No, sir.
Okay. So you said that you lived in apartment 1108 at the corner of Town Homes. That was in November of 2021.
Yes, sir.
And you had said that you had previously sold a Tahoe to Nelson and Ron.
Yes, sir.
And, but you claim to know nothing about a Buick LeSabre.
Correct.
So you're saying that Detective Boudreaux never asked you about the sale of the Buick LeSabre, only the Tahoe?
Yes, sir.
So on April 5th of 2022, whenever he went to speak with you in your apartments, he did not ask you about selling a white Buick around Thanksgiving previous year.
Or,
I'm sorry. Obviously, he did not ask you about selling a white Buick LeSabre around Thanksgiving to a couple of males.
yes, no, sir. I didn't.
So you didn't respond saying that you didn't know anything about the sale. Yeah.
My response was, he asked me about the Tahoe. And that's all I knew about was my Tahoe that I saw. That's it.
And you also testified that you did not know the complaining witness, Steve Carter,
Correct.
that you had, that you weren't familiar with his beautiful saber,
Correct.
that you never saw it outside the apartments,
Correct.
even though as you were here for his testimony, he testified that that vehicle has been there on and off for quite some time.
Right.
You never saw it.
Pay attention. Just it.
May I approach?
Yes, you may.
I'm showing you what's marked as States Exhibits 2 and 3. Do these look familiar to you? Okay. So you're telling this jury that these are not messages between you and Kevin Morado.
Exactly what I'm saying, that is not, that's what you're gonna need to, Nelson, Kevin, Morado.
Do you know anyone by the name of Chris Jacobs?
So,
I'm now showing you what's marked as States 13, 14. Do you recognize the locations in these images?
yes, sir,
Okay. And can you tell me where this is?
for the town,
And you recognize where this is located in reference to your apartment?
yes, sir,
Do you recognize this parking spot in particular?
not in particular,
Okay. So do either of these vehicles look familiar to you?
no, sir,
So, and you're saying that you had never seen a white vehicle saver 1987 in this spot?
correct, no, that is correct.
Showing you what's marked as States Exhibit 8. Do you recognize this photograph?
Yes, sir,
Can you tell me who this is in the photograph?
no, sir,
Okay. Now you realize, or you were here for the testimony, so you recall that this was used in the photo line.
yes, sir,
And if individuals that were involved in that photo lineup ID'd this picture, they would be identifying you, correct?
correct,
So you had said that at the time that you first encountered Nelson and Emerald, you were outside with your children.
yes, sir,
When you're outside with your children, would you consider yourself to be an observant parent?
an observant parent,
Yes.
yes, sir,
So in order to make sure that they're safe, you are very careful about the environment there.
yes, sir,
So you never noticed the vehicles that were around your apartment whenever you're outside?
okay,
That was a yes or no.
no, sir,
Um, I just want to clarify that despite the fact Detective Boudreaux testified that he only spoke to you about the way you are maintaining that he only spoke to you about the topic.
yes, sir,
No further questions.
Mr. Cameron?
Very quick. Now, President,
Yes, you may.
these text messages, and I remind you, you're under oath, so don't tell the truth. It's a felony. Okay? Have you ever had this phone number here, 548 88285, 409-548-8285. Has that ever been your number?
No, sir.
You know whose number that is or anything about that phone number?
No, sir.
That's what.
Um, no other questions, Ron?
They made this witness step down?
Yes, sir.
Okay. You can go back
Your
and
Honor,
have your
this
seat.
time, subject to the renewal of the motion that I made at the close of the state's case, we missed.
Okay,
So I'm renewing the motion at this time,
it is denied.
subject to that.
Okay. So ladies and gentlemen of the jury, the state and the defense have rested their cases. Well, state, do you have a rebuttal?
No rebuttal.
Okay, no rebuttal. Okay, ladies and gentlemen of the jury, the state and the defense have rested their cases. At this time, we have a charge that the court has prepared. Could you all step outside for a few minutes? We need to have a charge conference with the attorneys.
Okay.
Everyone may be seated. Let the record reflect that the court is back in session to call number M332118, case of style of the state of Texas versus Lanesha Dene Matoir. Let the record reflect that the attorneys for the state and the attorney for the defendant and the defendant are present in the courtroom. All members of the jury are present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the court's charge. Members of the jury, the defendant, Lanesha Danae Matoir, stands charged by information with the offense of theft of property, $750 or more, but less than $2,500, alleged to have been committed on or about the 22nd day of November 2021 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our laws provide that a person commits the offense of theft if she unlawfully appropriates property with intent to deprive the owner of such property. Appropriate, as used herein, means to exercise control over personal property. Appropriation of property is unlawful if it is without the owner's effective consent. Deprive, as used herein, means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right of possession to the property than the person charged. Possession means actual care, custody, control, or management of the property. Property, as used herein, means tangible personal property or documents, including money that represents or embodies anything of value. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious, subjective, or desire to cause the result. Now, if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of November of 2021 in Jefferson County, Texas, the defendant, Lanesha Danae Matoir, did unlawfully appropriate property by acquiring and exercising control of corporal personal property, namely a Buick automobile, without the effective consent of the owner, Keith Wayne Carter, with intent to deprive the said owner of said property, and that the value of at least $750, but less than $2,500, then you will find the defendant guilty of theft as charged in the information. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require the defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict page attached to this charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page of the charge is the verdict page. And this is the verdict page. You notice you have two lines, one at the top and one at the bottom. The top line says, we the jury find the defendant not guilty as charged in the information of theft. If this is your verdict, then your foreperson will sign here. It says, or we the jury find the defendant guilty as charged in the information of theft. If that is your verdict, then your foreperson will sign on this line. Does everyone understand? All right. Mr. Hubel, are you ready to proceed?
State's ready.
Okay, state, you have the right to open and close. Is 20 minutes enough? Or do you need, if you need more time, just let me know.
State will waive its right to open and reserve its right to close.
Okay. Mr. Kimler, you may proceed. If you need more than 20 minutes, just let me know.
Thank you.
You're welcome.
Afternoon, ladies and gentlemen. Look forward to the opportunity to address you directly about this case this morning. And now to our opportunity, please, we you represent somebody in a criminal case, it's a serious undertaking because you're talking about a person's liberty, their reputation, and it's a job that I take very seriously, especially in situations such as this, where at the outset, I had serious questions about the direction of this case, the responsibility is all more greater. In a few short moments, you're going to retire to the jury room and begin your deliberations. Court provides you with all the law necessary for you to decide the case that puts you in charge. You can take a copy of this back with you and review it. You can take any of these exhibits, put them into evidence and review those. You have a specific question or disagreement about a particular court from any witness's testimony, you can contact the bailiff for a written request for the court reporter to transcribe a very specific portion of the disputed testimony for you to review. And just say, give me all the testimony of this witness. You have to be very specific in that request. Part of the testimony, if there's a dispute, to be transcribed for your benefit of your deliberations. You'll notice in the court's charge that there's nothing in there that defines proof beyond a reasonable doubt, other than it's not proof beyond all falsity. Therefore, it's up to each of you to go back to the jury room to form your own mind how high the standard that is, as we discussed in more depth. And each of you will come up with your own conception of what proof beyond a reasonable doubt entails, and what that burden is for the state to meet. I would always suggest to you that because of, again, the seriousness of any criminal case, criminal charge, potentiality of deprivation, liberty, deprivation of rights, the stigma of a person's reputation, that it's a high burden. It's not an impossible burden, a very high burden. I'm sure that each of you will hold the state to that burden in your deliberations. Now, at the most fundamental level in this case is where I'm going to begin, just looking at the court's charge in space. The court's instructed that before a verdict of guilty is warranted, you have to believe beyond a reasonable doubt that Ms. Matoyer, as with anyone charged with the theft, has to appropriate property. This is paragraph 3 here. Appropriate property by acquiring and exercising control of corporeal personal property. In this case, we're talking about. So you have to believe that again, at the most fundamental level, that she believed beyond a reasonable doubt that she appropriated this property by acquiring and exercising control over it. Looking at the state's case in its most favorable light, even if you believe everything that they brought before you, they failed in that regard, or at least there's reasonable doubt about it, that she exercised control over the property that she acquired or appropriated the property by exercising control over it. Their testimony is, if you believe it, beyond a reasonable doubt, is that she was paid $200 for a vehicle that she had no interest in. And that's acquiring or exercising control over that vehicle by acquiring $200 for the vehicle and giving somebody permission to tow a vehicle. There's no testimony she ever keyed the vehicle. That would be controlled. She ever gave the key to somebody that you could infer control over the vehicle. No testimony she ever put her hands on the vehicle, did anything to show any kind of control over the vehicle, other than just taking $200 for it, even if you believe it. So even if you believe the state's case, they failed in this regard. Now I'm going to argue to you, obviously, that it's beyond much more than that, the problems with this case. But even at its most basic level, looking at this case, they failed to demonstrate beyond a reasonable doubt. She acquired or exercised control over the vehicle. Just by somebody giving her $200 for a vehicle. Now maybe she had the key, she gave him the key or something like that. Or maybe even helped him hook up the tow truck. Something to show control. None of that's in this case. But even setting that aside, you have to believe beyond a reasonable doubt, in order to convict her, that these two individuals, whoever they are, these two individuals, their testimony is to believe beyond a reasonable doubt. And that's not me saying that. That's Detective Booker saying. I cross-examined him yesterday. At the end of the cross-examination, it was an examination yesterday. I asked him, What do you have to establish Mr. Toyer's guilt in this case, other than these two guys saying she gave him $200,000? Nothing. That's it. To convict her, you have to believe these two guys beyond a reasonable doubt. I would suggest to you that there is reasonable doubt whether they're to be believed. And why do I say that? Looking at the facts of this case, you're looking at what the evidence is, because again, you have to determine what the facts are. Evidence isn't facts. Two different things. Looking at the evidence that's been adduced to the witness stand as objectively as you can, as objectively as I can. Right? What do we have? What do you know for certain? Well, you've got a videotape of a truck with this vehicle saver hooked up behind it, being hauled out of the parking lot of the apartments, right? There's no question about that. You got that. And the individuals these names are associated with are in the truck. You see it, I guess, from the video, but they admitted it. Right? I mean, you know that. That's an established fact. That's beyond a reasonable doubt. The people who have the truck hooked up, or the vehicle hooked up to their truck, the stolen vehicle hooked up to their truck, taking it out of the parking lot. For these two guys. So there's no question under these definitions in 3, right? There's no question that they appropriated property by acquiring, exercising control over the property because they're hooking up, they're towing it up. That's the thing. Everything's appropriated. Okay. So what do we know from there? Well, a little bit about the circumstances of them acquiring this vehicle, acquiring and establishing control over this vehicle. Well, what do we know? We know that the car, this Buick, was parked in this spot, safety good, safety good, right? It's parked in that spot, which is represented on this diagram that I had Mr. Carter draw right here. Okay. When those two hooked that car up to tow it, the front wheels were on. How do we know that? I mean, they didn't have a key to open it to put it in neutral, so they didn't have a key. But how do we know the front wheels were? Front wheels were on? Well, you can see the skid marks, right? And Mr. Carter, whose car it is, who looked at the scene, said, yeah, those skid marks went for 10, he said 10 yards, which means he probably played football, because that's how you measure after years of football in yards, but 10 yards or 30 feet around to the side of the apartments right here, and that's where the broken glass is, right? And there are bushes over here that screen this spot from the road, and the apartment house screens it from this side. So instead of just pulling the car out, well, instead of not breaking the window right here next to this vehicle, and instead of breaking the window maybe when it first clears the space, right? Where do they break the window? Well, they break it over here where nobody can see them. Where the glass is. Well, what does that show? What are you inferring to? Right? How do you know it is? You infer it from facts and circumstances. Well, that's one little fact, right? They didn't have a key. They had to break the glass. Where did they break the glass? Did they break the glass where it was most convenient to break the glass? No, they broke it on the side of the building where they couldn't be seen. What? There's some criminal intent. I'm just looking at this as a defense lawyer. I'm not a trained law enforcement professional with 27 years of investigating cases like that. But that just seems reasonable, right? So they break the window in a spot where nobody can see it, where they're screened from view. Then they haul the vehicle. And where did they take it? Well, we know they took it to scrap work. And how do we know that? Well, we've got this receipt from scrap. That will recycle it. And what does this receipt say? It says ownership. I hereby state that I am the lawful owner of the material described hereon. And I don't really see where any material is described other than a photograph. That I have a right to sell same, and that for payment received in full, hereby acknowledge I sell and convey title to scrap metals. Now, was the title conveyed to scrap metals? Well, evidently, scrap metals is assuming they got a title. They didn't get a title. This is a fraudulent market. If they're required to keep this pursuant to state regulations as part of their official records, that's a felony. The scrap works is in there. Because they didn't get a title. Kevin Antonio. Who's Kevin Antonio? Well, that's the name, at least the first three names. Of one of the individuals who towed the car. I would suggest stolen. Required the car, stolen. That's all. And underneath that, there's a license number. Now, you would think that maybe that might be some identification. Maybe it's a Texas driver's license, something that can identify. And then a plate number from their truck that brought it in this temporary plate. And then there's some screw. So is it really Kevin Antonio? Is that the person who brought it in? Or somebody else, or just a made up name? No. But it's on its face, it's suspicious because there's no title. It says that there's a title. So again, this is false. This is fraudulent. What does that indicate? Well, they're up to something. There's criminal activity between these things. If you're looking at it objectively. Now I'm getting Detective Boudreaux's fingers because remember, he didn't bother to even run this license number. He didn't bother to do it. He didn't bother. He didn't bother to run this temporary plate on that truck, even though there's been untold problems with criminal activity associated with these fake temporary plates on vehicles, such that the legislature has changed the law. He didn't bother to run that. So further indications that these two guys are up to something. Now we get into what Detective Boudreaux, how he investigated this case. And again, this is not some neophyte detective. All right, this guy has 27 years. He's over in Orange County before Jefferson County. He's here. He's been on the auto theft task force for I don't know how many years. On the classes. I mean, this is somebody who's supposed to know what he's doing investigating things. A seasoned police officer. What does he do? Well, he identifies the truck that stole the vehicle, that acquired the vehicle. And he puts out a be on the lookout, okay, with all law enforcement. Be on the lookout for this vehicle. Let me know this truck is a suspect in an auto theft. They stole a vehicle safe. So Officer Danny Buckholz from Fort Natchez Police Department is over on Bitterbow Road in Nederland. I guess maybe going to Justice of the Peace Burnett's office or something over in that neck of the woods outside of Fort Natchez, and he sees this truck parked in the house. And so he lets Detective Boudreaux know about that. Oh, I've located that truck you're looking for. It's over at this house off of Bitterbow Road in Nederland. You might want to take a look at it. Or talk to these people, and that's what the Detective Boudreaux does. So far, so good. He's following up on the lead at a location. So he goes to the house. Truck's not there, I think he said. He knocks on the door, talks to a lady and a little 10-year-old boy. And I would suggest to you, these two guys maybe even been in the house. They just weren't going to come to the door because it's the police. Maybe they're in the house, maybe they're in the back of the house, and they're not coming to the door. Maybe one of them's there and coming to the door. Anyway, he didn't talk to him at the house, but he let the kid know, the child know what he's there for. We're investigating the theft of a white Buick LeSabre, and these, this truck was identified as being involved in that, and they need to contact us. Contact me about this, anyway. So right now, those two know that they've been located, they've been identified as stealing this Buick LeSabre. They don't know how at this point because they didn't leave their names, you know. They were out there looking at a Tahoe, and maybe they saw this Buick LeSabre, and they had their eye on it. They went back at an opportune time and stole it. Didn't think anybody saw them, nobody got their names or anything. They took it to Scrap Works. They get some receipt, right, with Kevin Antonio on there, as a name. Nobody can trace that. It was some fraudulent driver's license number. They're clear, they're good. They're all right. Well, now the cops show up at their house. Won't ask them questions, come in and talk to them. So I would suggest to you probably what may have happened, maybe. Maybe they get together, we gotta figure something out, we towed that truck, we scrapped it, or we towed that car, we scrapped it. We gotta figure something out to cover this, well, what are we gonna say? We'll just say the woman that sold us that Tahoe who lives up there sold us that, that'll cover us. And we know what she looks like. So that's the story that they give the baby. And you know what? You believe it. As a 27-year police officer, he believes them beyond a reasonable doubt and charges Ms. Vittoria with this case. Does he even bother? Does he even bother to run those names and check them for warrants to assess their credibility? Right? What if you run that name and lo and behold, this guy's got a warrant for aggravated sexual assault with a child? Right, he's got some warrants. How does that affect his credibility? I thought as an investigating officer, if you're trying to decide who's telling you the truth. I mean, don't you think, and again, I'm not a law enforcement professional, but don't you think it would make sense to maybe kind of investigate these two to see what you're dealing with? When you're asking their version to explain why they were towing a stolen vehicle with a broken window out to a scrapyard with a false fraudulent receipt, when they're trying to explain that, don't you think you may want to explore their credibility a little bit before you jump off and charge her? Just to start with, right? How do we even know that that's their right name? That that's even their correct names? Kevin and Nelson. The rest of the names. How do you even know that that's their name? How do you know to this day that that's their names? Do you know that? Do you even know their real names? What proof is that they offered that those two names associated are actually those two individuals? You know, no effort was made to even identify them. And again, if they didn't have photo identification, there's method through fingerprints, through the computerized fingerprint system, take somebody's fingerprints to see who they are. And I'm not gonna make a big deal about them being in the country illegally. There's a lot of people here illegally, good people working, making a living. I don't regret them, honestly. But there's a real question of who they are. We know who she is, right? She's been charged. We know who she is. There's no question who she is. Alicia Vittoria, that's no question. Y'all agree with that? Y'all all know. What about them? These people making these allegations, if they expect you to believe beyond a reasonable doubt to convict her, because I anticipate that's what Mr. Hugel's gonna do when he stands up here to tell you why you should believe these two guys beyond a reasonable doubt to convict her. Because you have to believe it. So they come up with this story that she sold them, Ms. Vittoria sold them this car for $200. Having previously dealt with her on buying the Tahoe. They know where she lives. Heard her testimony. She's in front of her apartment, so they know where she lives. So when the detective Boudreaux drives them by the apartment complex, or actually I think they're in front of him driving, and they point, well, yeah, they're gonna point to where she lives. They know where she lives. Because they bought the Tahoe, of course. And to him, that's all he needs. These guys are credible, 100%. We're not gonna charge the guys who were towing the car off with the broken window, who pulled it out of the parking spot with the wheels locked and broke the window on the side of the building that we don't even know who they are. They took it to Scrap Works and got a fraudulent receipt. Nah, it's not them that stole the car. No. We believe their story. We believe them. We believe them. And she did it. It's her. She's the one. She's the one that committed the theft. Based on what? Based on what they said. What else do they have? What else do they have besides insanity? Well, where are those text messages? Here we go. Here's the text messages. Now we got some text. Right? These must be extremely important. These text messages are going to corroborate what they're saying about her, right? They're so important that the state has brought them in here. They put exhibit markers on them. They put them in there. These are really important, right? You would think if they're that important, again, that Detective Booger would have bothered to try to trace that number. And you remember, he couldn't tell you one way or another. Well, it could have been a prepaid. I don't know. I didn't do it. Could have been prepaid, man. I don't know. I didn't do it. But he would have tried to have seen, at least made an effort, right? To trace 5488285. To see who belonged to it, and come back, at least make the effort. So when I asked him that question in a criminal trial, where they're required to prove beyond a reasonable doubt she's guilty of theft, where she could be sent to jail for up to a year, make the effort, detective, right? To try to see who that number comes back to. If you're gonna try to use this to establish her guilt, to corroborate what these two are saying. He didn't do it, he didn't bother, he couldn't be bothered, just like he couldn't be bothered to wear a body cam and to record what she said to him when he came out to our apartment. If there's any question between her testimony and Lugo's testimony about what was said between those two, about whether he asked her about that Buick, she said he didn't, he said he did. Whose fault is that you can't resolve that? Whose fault is it for not wearing a body cam and recording that interview? So there's no question about what was said. Is it her fault? Or is it Detective Bingo's fault? Why didn't, if it's that important, you're gonna put a case on her, why don't you give her an opportunity to come down to the police station, sit in an interview room and be recorded, given a statement like he did these two, where what she says, there'd be no question what she says to him, so you could evaluate what she said about it. If there's any question what she said to him, that's on him. This is, I really gotta calm myself down because this case is absurd. This is absurd. If I were the prosecutor in this case, and I'm telling you all these things about those two, all the facts that we produced in this case showing that they stole that car, right? And I asked you to go back into the jury room and find beyond a reasonable doubt they stole the car, what would you do? Would you find them guilty based on everything that we've seen in court? They're the ones hauling the car off. They're the ones that break the window out. They're by the side of the building. They're the ones that lie on the receipt of Scrap Works. Or would you believe this cock and bull story from a defense lawyer that she sold him the car? If I'm a prosecutor, that's what I call that, right? When they're trying to get out, say that she is from a car theft. Oh, she told, there was a woman out there that told us we could buy that car. She didn't have a key. She didn't have a title. There's no bill of sale. There's no receipt. If I were a prosecutor, that makes me, that's laughable. To try to get themselves out of trouble. I don't understand this case. I don't understand it. I really don't. Because they could be convicted easily on beyond reasonable doubt standard. But the detective and the district attorney's office didn't decide to prosecute the people they have the evidence on that sold the car. They decided to prosecute her. And it would be different maybe if she had signed a bill of sale, if she was on video handing them a key, or she admitted to doing anything, right? That shows she should be charged with this case. Again, it's not how I see things, it's how you see things. I try to see things objectively. But obviously, people can see things in different ways. It's up to you as jurors to look at this case. And again, it's beyond a reasonable doubt. You have a reasonable doubt about any of this. If it is, the verdict's not. Again, it's difficult thinking that this is the standard that law enforcement applies to a case. But what's even more disturbing is that when it gets to the district attorney's office, and there's an intake, not Mr. Hugh, listen, there's an intake attorney up there looking at the facts of cases before they decide. Police send in a lot of cases to the DA's office. There's an intake attorney up there who has a law license, who's a lawyer, that reviews this stuff before charges are even submitted, before they're charged, to weed things out, to make decisions. And how this case got back, that's the attorney that should be trying this case, the one that's signed off on the complaint, not Mr. Ely. Because this is a tragedy that she was charged with this case. That she suffered the indignity of being placed in handcuffs, taken to the jail, handcuffed to the bench, searched at the counter, fingerprinted, photographed, put in a room, stripped down, told to squat and cough, dressed out in a jumpsuit, and stayed in jail until she was ready to make bond on these facts. When those two weren't charged, that's not right. But you don't have to answer them. You just have to look at the proof of the original now. Say guilty. It's up to you. I would simply suggest to you that the appropriate verdict in this case is not, but that's all you can do, jury. That's all we have to do. Thank God we have jury. Like I told you, when we died, it's not the police to get to decide guilt, it's not the DA's office, it's not judges, it's the people. By your verdict, you send a message not just to the criminals of the community, but you send a message, you set the standards for what kind of law enforcement you expect, and what we expect from the district attorney's office, and look at these cases more thoroughly than just rubber stamping everything that comes across your desk and forcing somebody to come down here and go to trial. There are people, I'm not digressing a little bit here. There are people in this county that are sitting in jail 2 and 3 years waiting to go to trial on felony cases and criminal charges because they can't post a bond. They're having to wait in jail that long to go to trial. How many of those people you think just plead guilty, get out, take probation, get out of jail on cases that are just maybe not as bad, not as weak as this one, but close to it just to get out of jail? Now they're on felony probation. Now they mess up on felony probation, they get revoked, now they have a felony conviction on a weak case. That's the system right now. But that doesn't have anything to do with this case, that's a digression. I just ask that you go back, you can look at the evidence in this case, and then what I hope is be considered to be the right thing, and find this, where you're not guilty, get restored a little bit of faith she may have in the criminal justice system.
Okay. Mr. Kilmer, you used, you have 26 minutes. Mr. Hill, you may proceed.
Thank you. I realize it's been a long week, it's Friday afternoon, but I thank you all very much for your patience and consideration in this case. The justice system would not work without y'all, and your attendance this week has not gone unnoticed. So thanks again. Listening to Mr. Kimler's closing argument, I anticipated, and it came to pass that he attempted to make this case about largely about the conduct of the Intellectual brothers. But they're not the ones that are on trial here. Ms. Matoyer is the ones on trial here. It's her conduct that we're here to talk about in this case, and it's her conduct that y'all will evaluate in regards to looking at each element and rendering a verdict in this case. Ms. Matoyer got up on the stand and testified as a defendant in the criminal case. She has every incentive to not say anything. And largely she didn't. She denied several things. She said that, Detective Boudreaux, spoke to her in a completely different manner in which he testified to earlier. Whereas the Inamorado brothers, when they testified, when they got up on the stand, they admitted to everything from their immigration status to the lack of a permit, but under the same threat of perjury as Mr. Boyer did, and they did so on the record. So, whenever we first began talking about this case in Bergire, I talked to you about the beyond a reasonable doubt standard, and I likened it to a puzzle. What I'm going to do now is put that puzzle together for you by talking about each individual element in this case and the evidence that proves it beyond a reasonable doubt. So first, I'm going to talk about some of the elements that are really no issue at this point because there was no argument from either side as to whether these elements were proven. So that first element is Jefferson County. The offense occurred in Jefferson County at the Port Arthur Townhomes. This was backed up by Nelson Inamorado, who testified that that was where he met he and his brother met Miss Latoya for the sale. This is in Port Arthur, Texas. That location is on video. The video that was provided and sponsored by Anita Anderson at the front gates of the apartment. The responding officer also responded to the apartments and talked to the complaining witness, Steve Carter. The Officer Seltzer took these pictures of the parking spot where the vehicle was taken from, also at the Port Arthur Townhomes in Jefferson County, Texas. Then we moved to on or about November 22nd of 2021. This also comes from States One, the video from the apartments. You can see in the top left corner of that video the date and time at which the vehicle is being removed from the Port Arthur Townhomes. Keith Carter reported the vehicle missing that night, and Officer Seltzer responded to the scene that night. Buick automobile. Kevin and Nelson, in testimony and in viewing State's Exhibit Number 1, have shown that the vehicle that they took that day, after it being sold to them by Ms. Latoya, was a 1997 Buick LeSabre. Keith Carter testified that that was his vehicle and that and States 15 is his title to that vehicle with all that information. And in fact, that was the vehicle that was reported stolen by Lieutenant Seltzer whenever he responded to the scene. Moving to value, Detective Earl Boudreaux with an price report marked as State Exhibit 16 showed that even the low retail price at the time of the offense for that vehicle was $1,250, which places it within the requirements for Class A misdemeanor of $750 or more, but less than $2,500. Onto the issue of identity. You saw when Nelson Inamorado was testifying that he was certain that the individual sitting at council table next to Mr. Keller was the individual who sold him the car that day. He was not aware of the name of the seller who sold him the car that day, but neither was Ms. Latoya aware of the seller who sold her her Tahoe at Best Buy Motors. So it's not unusual for someone to not know the name of the individual selling the vehicle. And then when he and his brother went to the station to make an identification of Ms. Latoya, they both identified photo number 4 in separate interviews, which was which is marked as State's Exhibit number 8. They identified the individual depicted in State's 8 as the seller. And in fact, during testimony, whenever I showed Nelson the photo lineup, he identified the defendant unprompted. While he was looking through the pages, he said, "This is her." What's interesting about that is that, as Ms. Matoyer said in her testimony, is that she had, prior to that at the sale of the Tahoe, it was only her and Nelson. So Kevin had not seen her at that point. So Kevin would have had to see her at a later time for him to be able to identify her individually in a photo lineup. That separate time, I submit to you, is the time that she sold the Buick LeSabre to the brothers together. Now, after the brothers identified the individual depicted in State's 8, Detective Boudreaux took that information and subsequently spoke with Ms. McGuire at the Forever Townhomes in apartment 1108. This is the same apartment that the then manager, Anitra Anderson, identified as Ms. McGuire's residence. So with that in mind, all the pieces and in regards to identity are lined up, and it indicates that the individual who committed this offense is properly identified as Lanesha Sawyer. To the issue of unlawful appropriation, I want to remind y'all that requires an individual to exercise control of property without the effective consent of the owner. So, since we've titled the element of identity, Nelson, Kevin, and Namorado ID Lanesha Matoyer as the seller. Ms. Matoyer, in orchestrating the sale, representing herself as the owner, and accepting payment for that vehicle, exercised control over the 1997 vehicle Sabre. She did so based on Mr. Carter's testimony without his consent in any way, shape, or form. So she did not have effective consent to sell that vehicle. And Mr. Kimler's argument that it was in fact the brothers that just they themselves stole the vehicle does not really line up, because based on Ms. Matoyer's own testimony, Nelson was handing out cards and placing cards like the ones in Defense Exhibit 1 all over the apartment, and in fact handed Ms. Matoyer a card like this herself. If they were going to go to the apartment to steal a vehicle, why would they leave all this identifying material around for them to be later found? Especially when the video of the front gates shows them towing the vehicle away. Would you think like that's the first person you would think of, the person who's handing out all the cards for the towing business. It doesn't make any sense that they would hand out all those cards and then decide to steal from the same property later. So moving on to intent to deprive. The intent to deprive is inferred from one's conduct. And generally speaking, when someone sells something for value, then they're not trying to get it back in any way. So whenever she sold the Buick LeSabre without the effective consent of the owner to individuals that she knows owns a towing business, the business models that they scrap the vehicles, she knew that they weren't getting it back. She had the intent to receive value for that and that it would ultimately be destroyed, so that she was depriving Mr. Carter of his property. with that. That covers all the elements that you'll need, in order to render a true verdict of guilty in this case. I would ask that you do so based on the facts, based on the testimony exhibits, that you'll be able to review, whenever you go back for deliberation. This is the jury charge that you'll receive. The highlighted portion down here, is the section that says, "We, the jury, find the defendant guilty as charged in the information of theft." I ask that when you get back there, and you deliberate after reviewing all the evidence, that you come back and render a true verdict of guilty by the court person signing under that, on that line. Thank you very much for your kind consideration.
Okay. Okay, ladies and gentlemen of the jury, we just finished the closing argument. Now, before we allow you to go into the jury room, there's one matter we must take care of, and that is one of you, one person on the jury is an alternate, and the alternate is not allowed to go in the jury room. The alternate is available in case one of the jurors is not able to complete their service as a juror. And so at this time, the alternate is juror number 13, Dat Tuan Din. Is that
Yes, Your Honor.
correct? Okay. So, Ms. Bailey, you need the charge. Everyone please stand. The jurors, you can follow the bailiff into the jury room. The court will be in recess until a verdict is reached. Mr. Den, you can have a seat either in the court or you can have a seat in the hall.
Yes, sir.
Whichever is convenient for you. Okay, the court will be in recess. The jury come back for the verdict. Let the record reflect that the court is back in session and calls number M 33218
Yes, we
You can go tell them that we know they have a verdict and just, okay, just tell them.
do that.
Let the record reflect that the court is back in session and calls number M 33218. Case is style of state of Texas versus Lanesha Dene Matoir. Let the record reflect that the attorneys for the state and the attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Mr. Mosby, come back. Will a bailiff please bring the jury into the courtroom?
Okay. They were getting the ball for their time.
Did they reach a verdict?
Yeah, they did.
Okay.
They did.
You can open up the doors in there. And do we have letters for them? Is she here? Everyone, please stand. Get those exhibits. Okay. Y'all gonna have a seat. Bailiff. Let the record reflect that the attorney for the state, the attorney for the defendant, and the defendant and members of the jury are present and seated in the courtroom, and calls number M 33218, case of style of state of Texas versus Lanesha Dene Matoir. Okay. Foreperson, have you reached a verdict in this case?
Yes, Your Honor.
Is this verdict unanimous? That is, one that is agreed upon by all the jurors.
Yes, sir.
Please hand the verdict form to the bailiff. Foreperson, is the verdict the unanimous verdict of all members of the jury?
Yes, sir.
Okay, you may be seated. We, the jury, find the defendant not guilty as charged in the information of theft. Anyone like the jury polled? State?
No.
Defense?
No.
Okay. Do we have letters? Yeah, you turning your badges, okay? And members of the jury, on behalf of the citizens here in Jefferson County, and the staff here in County Court at Law Number 2, I'd like to thank you for the time and attention that you've given to this case. I think we picked a jury on Tuesday, and today is Friday. And so we like to thank you for taking time out from your busy schedules to give your undivided attention to this case. I know that for some of you, it may have been a little trying. I noticed one thing about all the jurors, everybody was paying attention. So that's a good thing. Now, your jury service has concluded. That just simply means you're no longer jurors in this case because you've already reached a verdict. If you need any excuse or anything for your job, you can get that information from the district clerk's office. Oh, they still open? I think the district clerk's office is still open at this time. And again, I'd like to thank you for your time and attention. And as I mentioned to the other jurors, the other members who are on the panel with you, anytime you're in this area of this courtroom, please come and have a seat in your courtroom. See what goes on in Jefferson County, Texas. And I always use the term your courtroom because I know when you looked over the top of the door, you saw my name, Judge Terrence L. Holmes, Judge County Court at Law Number 2, and you probably said to yourself, oh, this is Judge Holmes' court. I'm in the right place. Well, you are in the right place, but this is not my court. This is your courtroom because I'm only an humble public servant serving the citizens of Jefferson County. You're the citizens of Jefferson County. And so anytime that you're in this area, please come have a seat in your courtroom. And I like to say there's some interesting things that happen in court. I always say that I prefer being in court serving the public than watching television. That's true. So some strange things do happen in court. You see me laughing, it's because what happened today, before you came in here, I thought I saw it. I thought I saw it all until what happened earlier. But anyway, anytime you're in the area, please have a seat in your courtroom. See what goes on here. And again, that's the peanut gallery, but it doesn't mean you can bring peanuts here and eat. But because this is not the Texas Roadhouse. Okay. Now again, I usually give handshakes, but we still have COVID. I'm gonna give everyone an air handshake, starting with the foreperson. Okay. Go to the back row. All right. Thank you for being here. And anytime in this area, please come back. Now, the lawyers may want to talk to you. You can talk to them if you want to. If you don't want to talk to them, you don't have to talk to them. You're not obligated to talk to anybody about your case. But if you want to talk to them, you can. The bailiff have some letters for you. Please read those letters. Drop us a line if you have anything you would like to say. Again, thank you for your time and attention. And before you leave, I always tell people this here. You notice that in this courtroom, I'm not the only person in this courtroom. And that's the reason why it's like that is because I can't do this job by myself. I have a court reporter, Ms. Ada Christie. I have 2 court coordinators. We have Ms. Trina Redmond and Ms. Glenda Segura. We have a bailiff. Well, actually, we have 2 bailiffs. I think y'all met her, Ms. Brenda Mosby, and we have Ms. Morton. She comes in and help out from time to time. The prosecutors who are in this case, we have Andrew Hubel sitting first chair, and we have Haley Simmons who sits second chair. Now, Ms. Simmons, I just swore you in last week.
April 15th.
Yeah, she passed the bar exam. And she was just sworn in April 15th. So this is her first trial sitting as second chair. Probably going to see her in the future trying more cases. Also, you met Mr. Ralph Kimley. He's one of our defense attorneys in Jefferson County. Actually, I could say Southeast Texas. Or maybe Texas. They call him the law posse. And Of course, you met Miss Lanisha Matoir, who's the defendant in this case. So again, ladies and gentlemen, thank you for your time and attention at this time. Now, if you have any questions, you can feel free to ask me. If you do not have any questions, you're excused, and everyone, please have a blessed day. And this will conclude cause number M332118, State of Texas versus Lanisha Danae Matoir. My name is Judge Terrence L. Holmes. I'm presiding judge here in County Court, Atlanta, number 2. Everyone, please have a blessed weekend.